Good morning. Hello, everyone. My name is Kristin Bremer, and I'm joined by my colleague, Clay Creps. We're partners in Tonkin Torp's Labor and Employment Group, and today we're here to talk about the new COVID-19 vaccine mandate in the health care industry here in Oregon. Before we get started, I'll make a few brief comments about this format. First, please know we are actively recording this webinar. You need not sign a disclosure, and no private information of yours will be shared. However, should you choose to participate in our Q&A session, your question may be recorded in association with your name. Also, with regard to questions, we certainly welcome them, so feel free to submit questions in the Q&A section of your Zoom app. We will do our best to answer as many questions as we can at the end. If we don't get to yours, we welcome you to reach out to Clay, myself, or the Tonkin Torp attorney that you usually work with. And finally, the disclosure, the information that we present today is not intended to be legal advice. So without further ado, let me fumble through technology and share my screen. Can everyone see that? Yes? Okay. All right. Okay, so today we're going to talk to you about the new mandates that we've seen here in Oregon. And there we are. There's Kristin and Clay. So to get started, I want to set the foundation for today. And pardon me, there we go. Too many screens up right now. So to set the foundation for today, I want to provide an overview of the recently announced COVID-19 vaccine mandates. So employers have seen a barrage of vaccine mandates coming from both the federal and state level, and they keep coming and they will continue to keep coming. So first, Governor Brown's orders. On August 4th, Governor Brown announced a new rule requiring weekly COVID-19 testing for employees in the healthcare setting, which could be waived with the proof of COVID-19 vaccination. And that was supposed to start September 30th. So in other words, there was a choice of either vaccinating or testing weekly for COVID-19. However, on August 19th, 2 weeks later, the governor announced that vaccines will be mandatory for healthcare workers starting October 18th, 2021, or when there is full FDA approval of the vaccine. So to be clear, there is no longer a testing alternative. Since the FDA has issued full approval of the Pfizer vaccine on August 23rd, the date for compliance with the governor's order is indeed October 18th. Next, the Oregon Health Authority, or OHA, has also issued rules. And as you know, that's why we're here today. This temporary rule mandates vaccines for all healthcare workers in Oregon, with the exception of those with medical conditions and religious beliefs that conflict with the mandate. We'll definitely spend some time on that. In a nutshell, those who do not comply with the rule by October 18th will be terminated. We'll also talk a little bit about that. The rule says employers may not employ, contract with, or accept volunteer services of those who don't present documentation of proof of vaccination or medical or religious exceptions by October 18th. We'll definitely be getting into the details of all of that very shortly. An important note here is that the Oregon Employment Department just announced that employees who are terminated for failure to comply with the vaccine mandates may not be able to collect unemployment benefits. So hopefully this will be an additional incentive for employees to comply. Next, on a federal level, President Biden announced last Thursday that vaccine requirements for federal employees and contractors, as well as employees of larger employers, and that's employers with more than 100 employees, will be required to get vaccinations as a condition of employment. So what's important for this audience is that, number one, if you're an employer that has more than 100 employees, this is going to apply to you, but also Biden's vaccine requirements also extend to healthcare providers who receive Medicaid and Medicare. And I assume a lot of that applies to this audience. So these sweeping mandates could apply to as many as 100 million Americans, or 2/3 of the country's workforce. President Biden has said that businesses who refuse to comply could face fines up to nearly $14,000 per violation. So we expect to see rules issued by the Department of Labor, specifically OSHA, very soon. So stay tuned for future webinars on the federal vaccine mandates. And finally, we also expect Oregon's legislature to be addressing the vaccine mandates in the 2022 session. So now I'll turn it over to Clay, who will discuss the details of the Oregon Health Authority's new COVID-19 vaccine mandates for healthcare workers.
Thanks, Kristin. While we are here in the context of healthcare providers and the OHA rule, we know that many employers have adopted their own vaccine mandates, and much of what we say today is going to be applicable to any employer that has a mandatory vaccine policy. But with respect to OHA's rule, essentially it says that on or before October 18, employers must receive from all covered individuals proof of full vaccination or documentation of a religious or medical exemption. And after October 18, a healthcare employer will not be allowed to employ, contract with, or accept volunteer services from a healthcare worker who either has not presented documentation of vaccination or one of the exemptions. In sum, action is required of an employer if employees do not get vaccinated. You can see that under the OHA rule, employers and healthcare workers themselves who fail to comply are subject to fines of $500 a day. So what is a healthcare setting? In addition to traditional medical facilities that we think of, hospitals, ambulatory care centers, those sorts of things, the definition of providers also includes alternative medicine such as acupuncture, homeopathy, and naturopathy. You can see the list on your screen. It includes long-term acute care facilities. It includes vehicles such as mobile clinics and ambulances, outpatient facilities, dental offices, retail pharmacies, and a school nurse's office. There are some narrow exceptions for the government and in-home care if the home is not licensed. For example, if you just have a healthcare provider in a private residence, doulas, home health plans, et cetera, therapists, then it wouldn't apply. However, if the home care workers providing care in an apartment complex, they wouldn't be subject to this rule. However, in-home care worker who provides care at a licensed adult foster care home is required to comply with the rule. This does not apply to healthcare settings operated on tribal lands or by private or by other nations. Kristin?
There we are. So the rule also talks about the definition of healthcare provider and staff. And so I'm going to be using the shorthand of healthcare worker for both of those. So under the definition of healthcare worker, first of all, it's very broad. It includes individuals who are paid and unpaid, who are working, learning, studying, assisting, observing, or volunteering. I think that's about as broad as we can imagine in a healthcare setting. And so it's also, the definition also talks about those who provide direct patient or residential care, and also those who have potential for direct or even indirect exposure to patients, residents, or infectious materials. So again, OHA has attempted to cast as broad of a net as possible. The definition is also listed specific kinds of workers that are covered. So any individual that's licensed by a healthcare regulatory board is going to be covered, as well as unlicensed caregivers. So this is your doctors, your CRNs, your nurses, your lab techs, all the way to the unlicensed caregiver who is working in the healthcare setting that Clay just talked about. It also covers those who may not work directly with patients, but have incidental or indirect exposure. And there's a couple of examples that are listed specifically in the rule, such as clerical, dietary, environmental services, laundry, administrative, billing, security, those types of things. So these are employees who might visit patients periodically, or they may have no patient interaction except they walk the same hallways, or those who work in the administration offices that are far from patients, but they're still in the same building. So they might use the same entrances and exits and cafeteria. OHA also issued FAQs. If you haven't taken a look at those, please visit the website because they're very helpful. They were last updated on September 9th, and they'll continue to be updated. The FAQs that were just issued add and clarify who healthcare workers are. So for example, dentists are also subject to this rule, despite the fact that the rule left out dentists in particular. That means that dental offices are also healthcare settings. Employees who work at retail pharmacies like Walgreens or CVS are also subject to the rule. So this isn't the employees that work outside the pharmacy, that work in the general store. Those aren't covered by the rule, but the employees who actually work in Walgreens pharmacies are covered by the rule. So the rule also excludes some individuals who may provide patient care, such as parents, family members, guardians, foster parents who care for children in their private home. So questions that we are getting often is, what about employees who are working 100% from their home office? And here I'm not talking about employees whose homes are licensed to provide healthcare services. Rather, I mean employees who perform their duties remotely from their home office. They are not considered to be working in a healthcare setting for the purposes of this rule. But if that healthcare worker goes to the healthcare setting, the hospital, the office, the lab, at any time for any reason, then they must comply with the vaccine mandate before they step foot in the location. So those who are 100% remote are not subject to the mandate. I also had questions about, what about people fixing your HVAC or stocking your vending machines? And OHA's FAQs actually address this, and they say likely these individuals are not covered by the mandate. So individuals who have jobs that are not related to the provision of healthcare, but which at times take them into the healthcare setting, are not intended to be included in the rule. The rule is intended to apply to individuals who routinely and regularly have direct patient contact or incidental and indirect exposure to patients. So let's briefly talk about what is proof of fully vaccinated status. So what that means is at least 14 days have passed since the person received the second dose of a 2-dose vaccine like Pfizer or Moderna, or the first dose of a single-dose vaccine like Johnson & Johnson. The documentation must be issued by a government, so it could be state or local, or a healthcare provider like a pharmacy. And it needs to include the individual's name, date of birth, the type of vaccine received, the dates the vaccine was received, and also the location or site or provider who gave the vaccine. Employees can present an actual hard copy of the vaccination card, or they can provide a copy or a digital picture. So here at Tonkin Torp, we take a picture with our iPhone of our card and send it to HR. The employee can also provide a printout of OHA's immunization registry. So what about the fake vaccination cards that we've been reading about? So some employers have been worrying about the risk of accepting phony documentation. So I'm here to say, fear not. The law does not impose on you the duty to be a document expert. So as long as the employer actually sees the documentation and the documentation appears to be facially valid, so it doesn't look like my 7-year-old made it, there's no unicorns on it, then the employer has fulfilled their obligation under the law. So to retain or to not retain a copy of the vaccination card. So employers are not required to keep a photocopy on file, although a lot of them do. And Clay will be speaking in a moment about the record keeping obligations under the mandate. So now the vast majority of the questions that Clay and I have received over the past few months relate to the religious and the medical exemptions. And I'm going to turn it over to Clay to discuss this important feature of the new mandate.
This is where we are getting so many questions, and this is where the rubber meets the road. We've got the mandate, and you can only be exempt from it if you have a medical or a religious exemption to it. So let's start with the medical exemption, because frankly, I think that's easier to deal with. This exemption is based on a physical or mental impairment that prevents an individual from receiving the vaccination. The best example you can come up with is, of course, that somebody is allergic to the vaccination. They would therefore have a medical exemption to receiving the vaccination, and therefore would be entitled to an accommodation. You can request documentation when someone presents a medical exemption. For the healthcare setting, you use the OHA form that is available on the OHA website. That's presented to the employee fills it out and returns it. If someone presents such an exemption, then you must provide a reasonable accommodation. And these accommodations apply equally to both the religious and the medical exemptions. So what might these accommodations be? They might be remote working, a leave of absence, placing someone in a separate office, masking and physical distancing, frequent testing. As we'll talk about, the burden there, of course, rests on the employer to pay for the testing and for the time taken to get tested, excluding someone from common areas, and possibly termination of employment. And that is, unless you have to provide that accommodation, unless there's undue hardship. In the medical arena, because we're talking about the Americans with Disabilities Act, undue hardship is a really high bar. You're probably not going to be able to establish that. However, remember, you have an obligation to keep your other employees safe as well. So that makes this all the more difficult. Well, what about if someone says, I want a medical exemption because there is a risk to my unborn baby, or this might affect my ability to have children. Now, neither of those is actually a disability. So you don't squarely fit under this medical exemption, but discrimination on the basis of pregnancy is also on the basis of sex and therefore is protected under Title VII. Further, under Oregon law, an employer needs to make reasonable accommodations for pregnancy. So if you're presented with one of those instances and the individual provides documentation of that, then I would suggest that you provide the reasonable accommodation at that point. So that is the medical exemption, and it's pretty easy. Now let's move to the religious exemption, and this is where we are receiving just so many inquiries from our clients about this. First, we know from Title VII of the Civil Rights Act of 1964 that an employer has an obligation to accommodate a sincerely held religious belief, observation, or practice. So let's start with the real basics. What is a religion? Well, religion isn't limited to what we traditionally think of: Christianity, Judaism, Islam, Hinduism, etc. It's not limited to that. It's much broader and includes generally recognized belief systems that are less common, and also individualized beliefs that are not a part of any generally recognized system. Essentially, a belief is religious if it addresses any ultimate concerns such as life, purpose, death, humanity's place in the universe. These are from cases. This is what the courts talk about. Right and wrong, or as part of a moral or ethical belief system. The belief doesn't have to be affiliated with any organized religion. It can be idiosyncratic, illogical, or unsupported by the believer's religious leaders. That is, an individual can say, for example, I'm Catholic, but my individual religious belief runs counter to Catholic doctrine. That doesn't matter. That's still a sincerely held religious belief. So the bar is incredibly low when it comes to saying what is a sincerely held religious belief. So when someone presents a sincerely held religious belief, the obligation then is to provide that accommodation. But what can you ask for in terms of the employee supporting this sincerely held religious belief? Well, for those of you in the healthcare setting, OHA again has provided that form where the individual is to set forth a statement describing the way in which the vaccination requirement conflicts with the religious observance, practice, or belief of the individual. So we know that you can ask for that in the healthcare setting. Otherwise, for other employers, yes, you can ask for a narrative from the individual describing what their religious belief is, or practice or observance, and how the vaccination mandate conflicts with that. Can you ask for further documentation of that? Well, the guidance isn't actually all that clear. The EEOC has said that only if you have an objective basis for questioning whether the belief is in fact religious or the sincerity of the belief can you ask for documentation. Boley seems to indicate that requesting such documentation is sort of the norm because you're asking to be relieved of complying with an employer's policy. So the question then becomes, what is inconsistent? What is an objective basis for questioning whether the belief is in fact religious or sincerely held? It might be acting inconsistently with the professed belief. What about, and we've all seen this, I'm sure you all have seen this in your workplace, I call them leapfroggers. And those are the people who say, well, I need a medical exemption to getting the vaccination. And they go to their doctor and their doctor won't give them that. And then they come back to you and say, well, now I have a religious exemption. I'm seeking a religious exemption to this vaccine mandate. I have a sincerely held religious belief that getting the vaccine runs counter to. It seems, and there is support for this from the EEOC, that when an individual first seeks one way, a secular way of being exempt from an employer's requirement, and then when that doesn't work, changes to a religious exemption, that is evidence of the fact that we may have a problem here. Boley, in its question and answers, regarding this seems to take a different approach. Boley seems to say that you have to examine each exemption request on its merits independently, not considering the other one. So we've got this tension, and but you should ask for that narrative and look at that narrative closely. Does it actually describe a religious basis for the exemption? Or does it actually talk about the safety of the vaccine or the fact that it wasn't fully approved by the FDA? If there are those sorts of things in there, then you may be on much stronger ground to deny that exemption because it's not actually based on a religious belief. However, we've all seen them now. There are websites out there that have these forms that employees are just copying and pasting that provides the reasoning for the religious exemption. The most common one that I have seen has to do with the fact that stem cells from fetuses, aborted fetuses, have been used in the development of the vaccinations. Now, my understanding is that with respect to Moderna and Pfizer, the stem cells are not actually used in the production of the vaccination, but with the Johnson & Johnson, they are. But most of these people are savvy enough to say, my objection is it was used in the development rather than in the actual production of the vaccination. So if we're looking at a question just came up, said if the religious request is general and they got a flu shot last year, what about that? That would be inconsistent behavior. If somebody's not saying I'm objecting on a religious basis because you use stem cells, but they're saying it's against my religion simply to get a vaccination, then the fact that last year this person got a flu vaccine would be great evidence that religious belief is not sincerely held. Okay, so when we get to, so the bottom line is you're going to have a really difficult time defeating the exemption request on the basis that either that the religious belief is not a religious belief because employees are getting very savvy, or that it is not sincerely held because the EEO instructs that the default is to assume that it is sincerely held. Once that happens, then we look at, is there an exception to the exemption? Well, what is required is that there be a reasonable accommodation to the requirement of the employer. And that's two parts. One is it reasonable? And secondly, does it cause an undue hardship? The reasonable, what that means is if there's more than one option, you don't necessarily have to give the employee the one they want. You can pick. But the one that is causing more discussion is the undue hardship. And undue hardship with respect to a religious accommodation is much different than it is with respect to the medical. Here we look basically, does it place more than a de minimis cost on the employer? And when we look at that, we say, number one, actual money, is this costing the employer money? And if it's more than a de minimis, which means very small, then that's an undue hardship and you don't have to provide it. And I'll get into an example of where that may actually be something that you could use to refuse a religious exemption. What is more likely is that this undue hardship is going to result from an impact on the workplace or an impact on other employees, such as causing other employees to have to work harder, et cetera. So you want to look at the nature of the workplace, the responsibilities of that specific employee, the cost to the employer relative to its operating costs, and the number of employees who will need the accommodation. What you want to do is look at how can this employee be accommodated? Can we allow them to work remotely? Can we, as I said before, can we put them in a separate office? Is frequent testing, weekly or twice weekly, allowed? And here's where the cost may be something that creates undue hardship, because under Oregon law, the employer has to pay for both the tests, for the tests, yes, and for the time off. Well, if you're a smaller employer and you have a number of employees who are seeking this exemption, when you aggregate those costs, that may in fact become more than de minimis. One of the places that I went is, does it cause undue hardship because having an unvaccinated person in the workplace creates a health risk to employees, to patients, or to or the general public? That seems like a good argument, but it also runs counter to the fact that OHA said you have to get the vaccine unless you fit in an exemption. Therefore, it seems that the assumption by OHA is that having someone in the workplace who is unvaccinated does not in fact create an undue hardship for the employer. And Kristin, I'll turn it back over to you now. I have a feeling we're going to get a lot of questions following up about these exemptions.
Yeah, you have one more. You have the record keeping requirements.
Oh, sorry about that. So what are the record keeping requirements? You don't have to, as Kristin said, you don't have to keep a copy. You don't have to actually keep the card. No, you do. But in that proof of vaccination or exemption must be maintained for 2 years. You have to provide that documentation to OHA upon request, but there is no reporting requirements. You don't have to every month say, okay, here's now who has provided the documentation. Remember, when you're talking about the proof, the medical exemption and the proof of vaccination, you have a confidentiality requirement under the Americans with Disabilities Act, which requires that all healthcare records must be maintained in separate files and locked. Now I'll turn it over to you, Kristin.
All right. We're running a little bit over, but so we can get through these pretty quickly. So as Clay alluded to just a moment ago, the question of who pays has been coming up a lot for us as well. So vaccines are free, so there's no worry there. But for those employers who are requiring weekly testing for an accommodation for those employees with medical or religious exemptions, this should be paid by the employer. So as Clay said, this could become very costly. And as to whether employers must pay employees for the time it takes to comply with the vaccine mandate, the answer is yes. According to BOLI, employers are required to pay employees for the time they receive the vaccine during the workday and outside of regular working hours. This is because getting a vaccine, or alternatively testing for exempt employees, is a condition of employment, and therefore it is considered an activity required by the employer in order to perform the work. So under Oregon's wage and hour laws, that time needs to be compensated. Now, on the other hand, if an employee is offered time during their regular schedule to get vaccinated and simply chooses voluntarily to get the required vaccination during their off duty, this time does not need to be paid by the employer. And the same goes for testing. So what happens to employees who refuse to comply with the rule? The answer seems really easy. They should just be terminated, right? Well, interestingly, OHA hesitates on this question. It seems like the rule is very clear. It says that an employer is forbidden from employing an employee, that's employing an employee that is covered by the law and has not complied with it. But OHA's FAQs stop short of mandating termination. So here's exactly what the FAQs say, the guidance they provide. So first it says, follow your workplace policies for discipline and discharge. So in other words, don't terminate an employee for failing to comply with the vaccine mandate, but rather terminate the employee under your workplace policies that say that employees must follow all directives of the employer, and if they fail to do so, they'll be terminated. Or you can terminate the employee for failure to comply with safety rules, something like that. It's also important to remember that compliance with mandates does not relieve an employer from compliance with the anti-discrimination laws. In other words, make sure you're following the ADA and Title VII's religious protections in administering the vaccine mandates. And also remember that an employer may not discriminate or terminate an employee who complains about actions that the employee believes violates local, state, or federal law. Now that actually violate, but that the employee has a good faith belief that they violate laws. So you may have an employee that expresses their disapproval of the mandates and claims that it's a violation of their rights or the Constitution. So be mindful here that when an employee is complaining that there's been a violation of the law, they are actually engaging in protected activity. So while an employer may be able to discipline or terminate an employee who refuses to comply with the vaccine mandate, the employer may not discipline or terminate an employee for questioning the legality of the mandate. So the important takeaway here is to make sure that your paperwork that documents discipline or discharge specifically and only references the refusal to comply with the vaccine mandate, not for complaining about the legality. So last but not least, I'm going to turn it over to Clay for next steps for you.
Okay, we'll go through this quickly. Review OHA's rules and the FAQs and the exemption forms. There's no substitute for them. It's important to have an individual or a department who's going to coordinate compliance here. So you want to set that up. Create your policy with clear requirements and timelines, and notify your employees of the consequences of not complying. I agree with Kristin, it's baffling to me that the rule says you can't employ somebody and then they waffle on, well, do you fire them? Well, of course you fire them. Create a confidential record keeping system if you don't already have one, and then consult with your legal advisor for any questions you have. I want to jump into the questions here because we've gotten a number of them and they're good. Here's a question that says, how does this work with the existing Oregon law, which states that healthcare employers cannot require vaccinations? That is an excellent question. It's one that we looked at immediately when we saw this come out. And frankly, it's contrary to the statute that says that. What am I advising employees to do? Comply with the OHA rule. Given these times, I think a court is going to say, yeah, you need to comply with that. Another question, the employee states that he, she, or they are a Christian and that their body is a temple as stated in the Bible and therefore should be exempt from having to get vaccinated. I like this. Really? Is that enough of a reason to get the exemption? And the answer is, it could be. Yes, that could be a sincerely held religious belief. The question, though, is what, and this is where you want to look at the narrative, and then you want to interview the person and get information. There's another question that says, can I ask if they've had other vaccinations? And Joy, the answer is yes, you can. And if they're engaging in behavior which seems contrary to their professed reason for wanting that religious exemption, then you have a good basis for denying that exemption. Joy, your question, I would assume the religious exemption would apply to all vaccines and not just COVID. It depends on how that exemption is articulated. If they're articulating it based on the stem cell aspect of this, then it would be just COVID. If it's simply my religious belief says I shouldn't get vaccinated, then absolutely you have a basis. Johnny, your question here about getting a flu shot last year but not getting one this year was said to be a change of belief. The EEOC has said that this inquiry into the sincerely held religious belief is a dynamic one and a fluid one, and that religious beliefs do change over time, and that you have to take that into account when evaluating these. Just looking. Kristin, you want to handle some of these?
You know what? I just popped off and able to actually see them. So, Devin, if you want to ask us questions, we're happy to answer them.
Sure. One of the questions we have is, do you have to notify employees that work around other employees who are not vaccinated? The question asks specifically due to religious reasons, but I think it's probably pertinent either way.
Yeah, so remember, vaccination status is medical information that needs to be protected, and it is confidential under the ADA. So it's important to not do that. However, I reflect back to a few months ago when we had a very different mask mandate in the office, and I had clients that had policies that allowed employees to not wear masks if they could show proof of vaccination. And when you have a warehouse of 300 employees, it's hard to keep track of who is and who isn't. So those who were vaccinated got a little star on their badge and didn't have to wear the mask. It was an easy reference for management to identify those. But again, that's the employee, voluntarily accepting a star on their badge in order for the exchange of not having to wear a mask. So again, keep it voluntary with the employees, but I would not recommend employers disclose that to other coworkers.
Great, thanks. We have another question. You addressed vendors such as people who are stocking vending machines in healthcare situations not being required to comply with that rule, but how about vendors like pharmacy reps and things like that coming into healthcare settings?
That's interesting. I have to ponder that one because yeah, in one sense, they're not going to have direct patient contact, nor will they have the incidental. They're not giving the regular care to patients, but they are frequently going into healthcare settings. So it's actually straddles both of what the FAQs are saying are not subject to the mandate and are. So I would have to noodle on that and sort of see how this plays out.
Well, what we do know, Kristin, is it's not addressed
Yeah.
in the rule or in the FAQ.
Right.
So,
yeah.
you know, what's the, so I guess the answer is, I think
more than likely that their employer is going to have some sort of mandate, particularly if they're a farm rep. But yeah, I mean, that's someone who works in the healthcare industry that's mostly going into healthcare settings. That's different than someone who's, you know, from Frito-Lay stocking the vending machines. But like Clay said, there is no guidance on that yet.
Yeah.
Great. Another question we have is, can I hire only vaccinated people going forward and not accept exemptions?
No.
Great.
No.
You can, you know, employers get to make all the difficult decisions and how they run their businesses, but you certainly cannot do it without risk. I can say that.
And the reason for that is if you don't hire someone who requires a medical exemption or a religious exemption, you are discriminating on the basis of disability or religion, and you don't want to be doing that.
Yeah, or pregnancy or gender.
Exactly.
Yeah.
Great. I think we're going to ask one more and then call it a day. This question is, when in doubt about an exemption, do you recommend granting or denying the exemption?
Granting.
Yeah.
Granting.
On the side of
Otherwise,
granting.
you're looking at a potential discrimination lawsuit or retaliation lawsuit. Yeah.
Okay, great.
All right, everyone. Thank you for joining us this morning. And like I said, please feel free, if we didn't get to your question, to reach out to me or Clay or the attorney that you work with here at Tonkin. Thanks so much. We appreciate it.
Thanks, everybody.
Stay safe.